Greetings all. Welcome to today's webinar on business exit and wind up strategy. We are pleased to have CA Pranav Damania with us today. With over 3 decades of experience in the fields of business setup, compliance, and strategic advisory, CA Pranav Damania is highly accomplished professional, holding multiple prestigious qualifications, including ICAI, ACCA UK, ICSI FCA, ACS, Diploma IFRS UK, and serving as an insolvency professional. He has built an exceptional track record of guiding businesses through complex challenges. His expertise lies in providing comprehensive business support, especially in the areas of entry and exit strategies for foreign companies, from helping startups navigate and um, from helping startups navigate in their starting stages to assisting established companies in optimizing their operations and improving their profitability. CA Pranav Damania has helped countless businesses thrive. We are excited for him to share his insights and strategies today, and we look forward to learn from his wealth of experience. Over to you, Pranav sir.
Thank you, Swaraj, for the introduction. So, first of all, thank you all for joining in the this time of the day when you are about to wind up everything. So that's why this topic is also about winding up. While you wind up the day, and we are going to deal with the winding up of the business. So I would suggest Swaraj to share the screen. So, friends, why this topic has been taken up, because we are all excited you know, to learn and to have the start of the business, but we never, kind of think about how to exit the business. So that is why this topic has been taken up. So that entry and exit both are important to the business. And today we are going to deal with the exit of the business. So yeah, so next you can go. So today's table of contents are is under. First of all, why there is the importance of exit. Then we deal with the various ways in which one can exit. We will also deal with the various reasons for the exit. Then I'm going to touch upon uh, the IBC exit, which is a liquidation under IBC. Then we are also going to touch upon voluntary liquidation under IBC. Thereafter, there is one simplified scheme of ROC exit scheme. And then we have another merger, amalgamation, demerger. Then there will be a sale, and there will be other modes of exit and question and answer. So we'll start with the importance of exit. So why there is a importance of exit? So for any businessman, he always wants to have certainty in terms of entry as well as exit. Now what happens, there are many geographies where entries are easy, but exit is very hard. And it used to be very hard in India as well. But over the years, we have also progressed. Our law has been simplified, and now exit has also been simplified to a very large extent. And that is why you see the exit itself has added a lot of weightage in ease of doing the business and ranking of the global ease of doing business. So we will deal with it, but This is how we are dealing with the importance of exit. Yeah, next. Now, there are various ways in which you can exit the business. One is the liquidation under the IBC. Second is the strike off under the Companies Act. Third is merger, demerger. Fourth is sale of the business. And fifth are the other ways which will deal with it. Yeah. So now, reason of exit. Yeah, this is very important to know that why people want to exit the business. See, there could be various reasons, and not necessarily there is a adverse reason to exit the business. There are, circumstances where promoter take a conscious call of exiting the business to preserve the value of the business, where he thinks that he is getting a very good value for his business. So it's called a value unlocking, where a startup who start the business journey and over a year, say 5, 6, 8 years, if he's getting good value, then many promoters have exited their own business. So we have example from many good and successful startups where the original startup has been exited, like the likes of Flipkart. Now it's been owned by Walmart, and the existing promoters are doing some other business. So one will be the value unlocking. Second, if there is no succession plan. So, so what happens that, sometimes we have seen the business where it's been built by, the businessman, but either they don't have someone from their family to follow that thing, or there is no succession plan. So at that time, if you start searching for some buyers to have it at the last moment, then you may not get the value. So you have to plan your exit wherever you feel that, there is no plan for the succession. So plan in advance. So again, it's a conscious call. Third is a regulatory action. So what happens is sometimes, there are some industries where there are, say, insurance or telecom or defense or some strategic sector where government uh, make some changes with respect to industry, wherein some licenses are deemed unuseful, and the business itself will have to wind up. That do happens wherever very rare case, but yes, it does happen where there is a some changes in the regulatory arena. Fourth is business downturn, which we are all familiar, where the business faces downturn in terms of the business, in terms of the profit, where the promoter are left with no choice but to wind up the business. And the fifth one is we have seen the many multinational group having presence in many countries. So sometimes they take decision to enter, and sometimes they make a decision to exit as well. So it is as per their group policy whether they want to invest further, or they want to invest in particular geography, or they want to expand in a particular geography, or they want to preserve their resources, or they find that they want to consolidate the business operation. Say suppose in Asia they may have 6, 7 manufacturing plant, but they might find at one time that they want to just have 2 manufacturing plant rather than 5 manufacturing plant in Asia. So in that case, they will consolidate everything at 2 places, and the other 3 or 4 places they will wind up. So it's a kind of again a group decision wherein they decide to exit from a particular country. So, and there could be many other reasons also for this exit. Uh, it could be many reasons, but Primarily, yes. One is a forceful where you have your business going down and you don't want a situation where it further erodes the value of the business. And second is where you take a conscious decision knowingly that the business is doing well, but you still want to have your value intact and get the maximum out of that business. So next, yeah. So I'm now going to touch upon a very hot topic, which is liquidation under IBC. Now, this is, as you may be aware, there is a code or a law called the Insolvency and Bankruptcy Code, wherein the exit has been made very easy and systematic. There could be a cases where there is insolvency involved, and that's a very separate chapter. I'm not going to deal in detail, but where the business have become insolvent, then any creditors, be it a financial creditor or any other creditor, can track that company for a resolution. So it's more of a resolution, but in case the resolution fails, then it goes for the liquidation. So once it is liquidated, the company gets dissolved, and that's called another exit. However, now we are going to deal with another situation where the company has nothing to do with insolvency. The company is fully solvent. Solvent in the sense they have their assets, which is more than their liabilities. So in that case, it's still governed under this same code, which is IBC, but it's a very simplified exit scheme. So what are the features in this? One is this entire liquidation under IBC is a shareholder driven process. So shareholders are the king of this entire process. So it is like the owners or the shareholders or the partners who take the decision to get out of the business voluntarily so that they can, return or they can get their money back from the business, whatever it is. This happens where, they have run the company for so many years and there are some money lying in here. But either they want to exit the business or they find some other business suitable. And this is where they want to close down this particular business. As I said earlier, also the multinational company also does a lot of this liquidation where they have set up the Indian subsidiary, but later on they find that they want to exit the business. Or because of some changes in the regulation, now the Indian company is no more functional. So in that case, the company is still solvent. Solvent, again, I'm saying it's the assets are more than the liabilities. So you are going to pay to everyone, all the creditors, and still you want to wind up. So it's a completely a shareholder driven process. And here the other beauty is that the members or the shareholders appoint the liquidator. It's not something that, either a court or tribunal or some government agency appoints a liquidator. So members have a liberty to choose the liquidator with whom they want to work. So it's a very cooperative way to liquidate the entire process. The third major feature is the liquidator is given a sufficient authority to carry out the liquidation. So it means that there were laws under, previously under the Companies Act where liquidator has to go to many authorities, many government agencies to take their prior approval. Now here under IBC, this all the prior approval has been done away with. So liquidator, while has been given power, of course he has to exercise his power in a very diligent way where he has to ensure that nobody's interest is affected due to this liquidation. But yes, he doesn't need to go to any other government agency for a prior approval. So again, so no need to take any further approval. So as I said, the only approving final authority is NCLT, and before that, he doesn't need to go any government agency, unless of course there are some pending assessment or pending legal proceedings are there. Here we have seen in this shareholder get their money back in 3 4 months. So once you take a decision to close down the business and you start a liquidation, it is very possible that the owners get their money back in 3 4 months. And this is where the owners are interested into that how soon they can get their money back from the business. And we have seen cases where owners can get the money back in 3 4 months also. And the other final authority is NCLT. Once they pass the order, it is applicable to all. So it is applicable to all the creditors, it is applicable to all government agency, it is applicable to all tax departments. So once this order is there, nobody can challenge it in any court of the law. So this is a final and sacrosanct. So these are the features of liquidation under IBC. So we'll go to next. Yeah. So I'll touch upon what are the requirements under this voluntary liquidation under IBC. One is the essential conditions. So essential conditions under voluntary liquidation are only two. One is the company has to be solvent. So the directors who are making the first decision to close down the business and go for the voluntary liquidation has to ensure that the company is solvent. They have to draw the financial statement as on date, and as per the recent valuation, they need to arrive at the solvency condition of the business. And second, this liquidation should not harm anyone's interest, or it should not have any intention to defraud any creditors. So these are the two very broad and essential conditions which one needs to fulfill to start the liquidation. And once they start the liquidation by passing a special resolution in the members meeting. In that meeting, they appoint the liquidator also, who is the insolvency professional registered with the IDBI. So, as we have seen earlier, that the liquidator is appointed by the members of their choice, and he is a registered insolvency professional with IDBI. So, what he does? So, once he step in, basically he gets all the powers of to ensure that the company gets liquidated, and he has all the authorities to either liquidate the assets, pay off the liabilities, and do all the acts which is necessary to liquidate the company. So what he does essentially, once he gets appointed, within 5 days, he make a public announcement in the newspaper of the wide circulation about the saying statement that the company has decided to wind up through the special resolution on so and so date, and that is your liquidation commencement date. And anyone who has a claim against this company, they can make their claim, they can submit their claim to the liquidator in a particular form. So it is a public announcement, it is a declaration, and it is an announcement to public at large saying that this company is under liquidation. So anyone who has a claim against company, please submit those claims within 30 days. So that is one thing. Second, sale of assets. So after making public announcement and after he gets a claim, he make a list of claimants and list of creditors, and thereafter his primary duty is to sell all the assets. So whatever assets are there of the company, he has to sell in a public auction, get those money out of the sale deposited into a particular escrow account, and that money is to be used for payment of the liabilities, payment of the liquidation expense, and then whatever remains will be paid to the shareholders. Okay, the other mode is you can either sell the asset or you can distribute the asset also. So where there are some assets which are not easily sellable, say for a real estate company where the real estate project is completed, but they still have some unsold inventory, very few unsold inventory, and the owner doesn't want to wait till the sale of it. So what they said that, okay, we are the owners, so let me take those assets itself rather than you sell it and in the market, which might fetch a lower value because of the existing market condition. So I might take those assets as a part of my ownership, and I may deal with it in the future the way I want to do it. So distribution of assets is also allowed under this. Then there is some tax consideration. So voluntary liquidation, while it gives a lot of power, but we also need to ensure that all the tax consideration has been met. So whether it is GST or whether it is income tax or any other tax laws which is applicable to the company has to observe, the company has to follow those tax payment, tax filings, and all the compliances which is applicable to the company. So there could be a tax on distribution of profits to the owners. So all these things needs to be taken care of. Yeah, and this is where it is very suitable, where the company is hugely solvent, but and also has a huge asset base or the huge bank balance in terms of say bank FD or liquid fund or in mutual fund. The best way to get those money is to go for this voluntary liquidation and get your money back in 3-4 months. So these are essential right from essential condition right the commencement till end. And it is a very nowadays a very popular scheme to get your money back from the business. As I said, only two essential conditions. Once you fulfill, you start it, and the liquidator has a lot of power, essentially all the powers to do the liquidation. It can, get completed in 3-4 months also. So while now we've dealt with it, now we will go for what are the other ways you can do the business wind up. Next. So there is one more cost-effective scheme which is called a ROC strike-off, where registrar of company strike off the name of the company. Essentially, once they strike off the name, it means the company is no more existing in the business or in the register of companies. So this can also be done voluntarily, or this can be initiated by ROC itself if they find suitable course to do it. So that is one way they can do it. And where you can take this benefit of this is where the company does not have a significant asset, where the company has just formed or has just put in some capital, but they have never take off or they have never done the business. It's the best way to close down the business. Don't need to go for voluntary liquidation, which we have discussed earlier, because there you need to go to NCLT and there are some costs involved. But here it's a very cost effective and very simple scheme. You can exit. But here the catch is that you need to give indemnity for 20 years. So you're in a way bound for 20 years if something happens, if some notices come, or if there are some proceeding which is started against company, then you have still that hanging sword on you for 20 years. So so many companies or many promoters have run the business already. They don't want to have the situation where they are susceptible to a future claim, and that too for 20 years. So it's quite a long period. So as I said, the one who has just formed the company, just put in some capital and never took off, it's best way to wind up. And there are some conditions that the company should be defunct for 2 years at least before this, and you need to give the audited statement and the other procedure aspect is there. But this is popular, cost effective, but has its pitfall also. Say. So these are the two very famous thing. Uh, But as I said, now people are moving more towards the voluntary liquidation because it's a curtail down forever. Nobody can challenge that order. Now the third situation where there are some corporate action in terms of merger, amalgamation, and demerger, where the company has some three, four businesses. They can demerge one of the business and exit that business altogether so that the promoter can completely focus energy on the remaining business. That's part of corporate strategy where they want to focus on some areas and they don't want to focus on another area. They might also go for merger where they find merging with someone will create a bigger value. So where there are two competitors, but if they think that coming together will create a huge empire, then they may go for merger amalgamation also. Again, it requires a tribunal consent or tribunal order, where you need to prepare a scheme and give it to the tribunal for the approval. But there are, some more consent and more approval required in this. So, as we said, it's corporate action. Again, value unlocking is the main motive of going under this merger, amalgamation, demerger. But fortunately, it's now governed under NCLT, which is a special code. So uh, we are seeing a good amount of merger, amalgamation, demerger happening, and approval rate is also coming fast now because it is now under NCLT. Yeah, next. Next. Yeah, sale. So what happens that sometimes you are selling the entire business unit. I'm not saying the entire company, but as I said, there could be two, three division, two, three businesses, two, three independent subsidiaries also could be possible. And there could be many reasons. So some of the reasons you just listed down that, there could be a loss-making unit, they want to just get rid of it. Second, where the company has taken a lot of debt, and as a part of debt restructuring, they want to exit some of the business, get some cash in, and put that cash so that the debt level will be reduced. And third, as we said, that when there is no succession plan, there is no way just to sell this business. Fourth, yes, you sell it consciously to get a better valuation. So what happens that when you do the business for many years and you find at a given point of time the valuation of the business you're getting is quite high as compared to your own assessment, you might take to attempt to take a decision to exit so that you get the maximum value of the business. So these are some of the circumstances where sale as a going concern is also possible. Uh, Now, these are, other modes where, buybacks are happening. You buy back the capital and slowly, and then you wind up. Then you need to wait at least for 4 or 5 years for doing that. Second is hive of loss-making units, where we also discussed that if the company has loss-making unit, then you just hive off to another entity so that the remaining entity will have a better valuation for the profit-making units. The third one is it winding up by tribunal under the Companies Act. So there are section 271 to 273 which deals with it, where the winding up is ordered by tribunal or the creditors or the members, where they find they cannot carry on the business any longer, and the best way to preserve the value or to protect the rights of creditor is to go for winding up under the Companies Act. Again, this is also an existing scheme, but due to inherent limitation, many are not opting for it. But depending on situation, depending on the fact of the case, you can also think of doing this winding up under the tribunal also. Yeah. So now, so essentially, we have discussed all the modes of winding up the business. Yeah, so I'm pretty much done with the presentation. I would love to have question and answer in next 4 5 minutes, because we have another 4 to 5 minutes left. Uh, so I would love to have any question if you have. Yeah, one question has come, which is they're asking that what is the time frame for voluntary liquidation? So voluntary liquidation time frame, as I said, if the company does not have any legal proceeding pending against it, or the company is very clean, they have a very clean tax records, they have absolutely nothing pending against it. Then, as I said, we can do complete liquidation within 3 to 4 months in terms of returning the money to the shareholders. So while there is, public announcement for 30 days, and then there's a preliminary report for 45 days, and then you to sell, they said you to get your money at one escrow account and then distribute. This can all happen in 3 4 months if the company does not have anything pending at any level. So 3 4 months is a realistic timeline for the liquidation of the company. But thereafter, of course, for the dissolution, it might take time because it needs NCLT approval. So while I said there are two things, liquidation process can be over as fast as 3 4 months. The dissolution might take time because it all depends on how NCLT will look at it. Because NCLT is a quasi-judicial court where there are many cases they have to deal with the Companies Act, IBC. So depending on the queue system, the cases will be taken up, and it will be dealt with. There will be hearing of such cases, uh, and so there it might take time, but that is only a dissolution order, which might take time. So two phases, liquidation, yes, uh, can be in 3 4 months. Dissolution might take time depending on the NCLT workload. There is one query. Can voluntary liquidation take place if there is a conflict between the owners of the company? Okay, that's a very typical question. That what if the owners are not in sync with each other? So my answer is that One of the condition procedurally, it needs a special resolution. So it requires 76% consent of the members. So if 90%, so suppose you have two members, one is having 90%, one is having 10%. If 90% is in agreeing with the liquidation process, even if 10% is not in agreement, you can still go ahead because a special resolution gets passed in with the required majority. So we can very well do this liquidation. And 10% that minority cannot challenge it because it is in accordance with the required voting share. But if you have a 50-50 kind of situation and they both are not in agreement with each other, then it is difficult. It is not possible. I sincerely thank you all for attending this webinar.